Welcome to a special program on voting rights barriers in California today. I'm Karen Clopton, Chief Judge for the California Public Utilities Commission. Today, I'm serving in the capacity of past president of the League of Women Voters of San Francisco. We're in a wonderful partnership with the Lawyers Committee on Civil Rights of the San Francisco Bay Area. They've written a wonderful and comprehensive study on voting rights barriers and discrimination in 21st century California, 2000 through 2013. We will be talking about the findings of the study, which addressed several fairness and access issues, including voter dilution and voter suppression, disenfranchisement of currently and formerly incarcerated Californians, language accessibility, and disability accessibility and accommodation. We're very fortunate to have with us today Joanna Cuevas Ingram, an Equal Justice Works Voting Rights Fellow and attorney. She works with the Lawyers Committee on Civil Rights. Joanna, can you tell us about the importance of the Voting Rights Act and what was the impetus for this important study that you researched?
This study was produced in response to Chief Justice Roberts' opinion in Shelby County versus Holder, which came out in June of last year, June 2013, which struck down a very key provision of the Federal Voting Rights Act. Currently in Congress, our legislators are considering a Voting Rights Act, Amendment Act of 2014, which would currently, in its current iteration, provide a rolling coverage formula for over 15 years of voting rights violations. We wanted to show at the state and federal level that California is not immune to discrimination and that we still have problems that we need to address that are systemic, in addition to those that occur at the local level.
We're joined now by Rachel Evans, the co-author of this study, and she is from Georgetown. She's a legal fellow at the Lawyers Committee for Civil Rights. Welcome, Rachel.
Thank you.
When the two of you, Joanna and Rachel, were working on this report, what was the impetus? How did Shelby, the decision in Shelby that you just spoke about, how did that impact voting rights in California in terms of the dilution issue?
Well, it definitely had a huge impact here in California. And as we mentioned earlier, Monterey County was removed from pre-clearance coverage under Section 5 of the Voting Rights Act. And again, that was to get permission from the federal government before they changed their election systems. There was a case called Lopez versus Monterey County, which addressed vote dilution. What is vote dilution, right? Vote dilution occurs when you have a community that is, maybe it's historically majority white, and then you have a community that is not white, that is not a majority of that community. So for example, in an at-large, what we'd call an at-large election system, where everybody in that city votes for every city council member, and that community is 60% white, or the voters are 60% white and 40% Latino. In that at-large system, every single time, if 60% of the white voters vote one way and 40% of the Latino voters vote another way, and both groups vote pretty cohesively with their own ethnic group, you have what we call racially polarized voting, what others may call the segregation of the electorate. And when that occurs in such a way as it prevents the minority community from having an equal vote to elect a candidate of choice, that is vote dilution.
And what is the solution to vote dilution?
Well, there are a couple of legal protections that we have in place, thanks in part to the Federal Voting Rights Act of 1965. Section 2, which we talked about earlier, is permanent. It can be, it's useful for communities that have experienced vote dilution and keep voting for candidates that never get elected because every single time they're being blocked by a cohesive white voting bloc. Section 2 can provide a remedy by splitting up an at-large system into a district-based system where communities of color can actually have access to a meaningful right to vote and elect a candidate who lives in their district, who reflects the needs of the community, who's accountable to the community. We also have the California Voting Rights Act, which was enacted over a decade ago and has been very successful here in California in ensuring that vote dilution stops dead in its tracks and actually breaks up at-large systems that do just that and creates these district-based systems. But vote dilution can continue to occur in district-based systems too. Under Section 2, there have been many cases across the country, including some here in California that we talked about. Lopez versus Monterey County was a Section 5 case that looked at Section 2. But not to get too deep into the weeds here, this can happen where communities are broken up into smaller and smaller fractions where they have no meaningful voice, or they can be packed into one district so they can only elect one candidate out of a slate of 5 city council members in a local jurisdiction, for example. So vote dilution impacts California because over the last 10 years, we've seen 140 jurisdictions voluntarily change from an at-large system to a district-based system to comply with the California Voting Rights Act. And over 20 cases filed, 16 of which have already been successful either on the merits or they've settled with the plaintiffs. So we know that vote dilution either persists in California or that communities are on the lookout to see whether their local boards, school boards, city councils, local governing boards are truly diverse and truly representative of the community.
Rachel, how can counties provide better training to prevent issues like suppression, intimidation, and deception?
You're very right that here in California, even in the 21st century, we're seeing issues of voter intimidation and voter suppression and voter deception. And I think you're right that one of the larger causes of these issues, or something that perpetuates it, is poor poll worker training. Here in the United States, we have a very decentralized system, and so the training of poll workers is left up to the individual counties. And so I think that we need to have a more unified system and a system with checks and balances to ensure that each of these poll workers is trained adequately. This is especially important because we rely on volunteers to do our polling and poll worker trainings. And so if we don't have adequate training in place and a cohesive system throughout the state, then we will continue to see problems on election day in the polling stations, in the precincts.
We're in California. Do we really have voter suppression?
We truly do. It's disturbing, especially in the 21st century, that we still see issues throughout the state of voter intimidation and voter deception. Voter intimidation occurs when a person, a voter, a community is intimidated through violence or threats of violence or threats of some other thing happening to them. And this intimidation changes the way that they vote or prevents them from voting at all. As I said before, these poll workers are volunteers. And so personally, I think that there needs to be better recruitment of volunteers, encouraging people that have an impact in their communities to go ahead and serve and do this public duty. And along with that, structurally, we need to have a system in place that ensures that each of these poll workers receives the training in the laws, knows the laws, and that there's some sort of checks and balances in each polling station to ensure that no impropriety is happening, either by third parties or the poll workers themselves.
Thank you, Rachel and Joanna, for your important work on this study. For more information about the League of Women Voters of San Francisco and ways for you to get involved in our important work on voting rights, please visit our website at LWVSF.org. Or to find out more information about this important study on voting rights barriers in California, please go to LCCR.com. We're continuing our discussion today on voting rights barriers in California. We're being joined by Dorsey Nunn, the Executive Director of the Legal Services for Prisoners with Children. He's also the co-founder of All of Us or None. We're going to be talking about the disenfranchisement of Californians with criminal convictions. What really does disenfranchisement mean? And is it the legacy of slavery by another name? Eligible voters are prohibited from voting, but why? And is it by law or by fact? De jure disenfranchisement or de facto disenfranchisement? The most interesting factual aspects of disenfranchisement are the disproportionate impacts on the African American and Latino populations. African Americans, Latinos, and other non-white populations make up 76% of California's jail and prison populations. Yet, they comprise only 56% of California's adult male population. Among incarcerated males, Latinos make up 41% and African Americans 29%. These populations, which together constitute a vast majority of California's incarcerated population, are populations that have faced a long history of barriers to voting. Dorsey, could you talk to us about this history of disenfranchisement?
The first thing I think I need to do is you introduce yourself as the past president of the League of Women Voters, who initiated voting rights in the state of California for incarcerated and formerly incarcerated people. You also stood up in a way and fought extremely hard in the case the League of Women Voters versus Bruce McPherson. And you also engaged in the current reiteration of that fight that secures voting rights for people in the county jail and formerly incarcerated people like me. So when we talk about the question of voting rights, it's just a shorthand conversation that talks about the full restoration of our rights, because there's other questions arising out the question of voting rights that's extremely important. We have in conversations within the formerly incarcerated and convicted people's movement around the question of are we citizens of the United States if we don't have the right to cast the vote? And in certain states, you would have the right to vote, but in those states that you would have the right to vote as a prisoner, they're predominantly white states with a very minimal population of people of color. So it's like when you talk about the new Jim Crow, I think that thing is experienced in a real fundamental way when it comes to the question of voting rights in all states, not just of the state of California. I think it's practiced throughout the United States. Questions that arise out of the concept of voting that we have real concerns about is, do we get to serve on juries? Are we citizens of the country? Or, you know, if we can't vote, are we a stateless people when we incarcerated? Or all questions are being raised about the issue of voting.
As of 2004, more African American men were disenfranchised than in 1870. Michelle Alexander points this out, as you just mentioned, in the new Jim Crow. The year that the 15th Amendment was ratified in 1870, prohibiting laws that explicitly deny the right to vote on the basis of race, well, why haven't we come farther in all this time? If starting in 1870, the 15th Amendment was enacted, why do we need the Voting Rights Act?
God, I would call it benign neglect, but I think it's something a lot more serious than benign neglect. I actually think that it's the practice of racism and supremacy. So I don't necessarily see it as accidental or people ignoring the fact You know, you would have to be blind or stupid not to recognize them when you walk into any jail or any prison inside the United States. You're going to see a disproportionate number of people of color there. I would beg that they are looking at it, and I would suggest that it is on purpose. So if it wasn't on purpose, then why are we having this big old struggle around voter ID and the rest of the theft? So it's not accidental that people are taking people's vote. They're taking it with a purpose.
Let's talk a little bit about the challenges, as you mentioned earlier, including McPherson and our successful challenge to address the California Constitution and not disenfranchising every individual who served a sentence for a felony conviction. Could you address that, Joanna?
Yes, I could. So going back to, just linking back to Michelle Alexander's comments in the new Jim Crow, Section 2 of the 14th Amendment allows states to disenfranchise voters based on a criminal conviction. It doesn't make it a right or requirement for them to do so, it just is permissive. And so California has done that. Our Constitution, unfortunately, does disenfranchise Californians who are in state prison or on state parole. However, as Dorsey mentioned, Legal Women Voters and all of us who are non-legal legal services for prisoners with children were involved in a case. Legal Women Voters versus McPherson was the title name of that case, but both groups were involved in 2006. That case in the California Court of Appeal really clarified that Californians who are not in state prison, not on parole, who are on probation, have the right to vote. And also look back at what the League of Women Voters had done back in the 1970s in expanding the franchise and making very clear that that constitutional language was meant to be read very narrowly and not broadly. That case was very successful, but there's still been problems, right? There's still problems in terms of the implementation of that ruling. We have two kinds of disenfranchisement that occur. There's the de jure disenfranchisement, and that's what's in the law, what the law actually says, the California State Constitution. And then there's de facto disenfranchisement, which occurs when there's misinformation, poor training, and then sometimes, as Dorsey said, malinformation.
What is the positive light? What is the shining light at the end of this tunnel?
For me, I think that registering people in the county jail and insisting that people have the ability to have access to their right, for one. But for me, the shining object is that I'm here and formerly incarcerated people are demanding their right and the full restoration of those rights.
That's right. There are 350,000 Californians today that under McPherson and ostensibly under Scott v. Bowen would be eligible to vote if the law was interpreted clearly and narrowly so that people would have access to the right to vote. But what really needs to happen is our state needs to fully reconsider the disenfranchisement of any Californian with a criminal conviction. We know, based on mass incarceration over the last 20, 30 years, the prison population has doubled. We know there are problems with overcrowding here in California, and we know that the population is disproportionately of color. We need to address the issue of disenfranchisement as a voting rights issue, as a racial justice issue.
And as we move towards registering more people to vote and making sure that those who are in the jails and in other places like that who are actually eligible to vote, we need collaboration and partnerships with the sheriff's departments, with the police departments, right, and with the Department of Corrections. So it's a matter of education as well as collaboration. That's
right. And one of the recommendations we make in this report is that these agencies, sheriff's departments, probation departments, other public agencies that are serving this population become registration agencies under the National Voter Registration Act of 1993, so that like the DMVs, like social service agencies, they are providing a social service to our community, particularly with the reentry work that's happening now in California. They need to provide access to the right to vote.
Thank you so much, Dorsey, for coming today and talking about these important issues, and I greatly appreciate your acknowledgement of the role of the League of Women Voters in securing the franchise for previously incarcerated citizens of California.
Thank you.
Yeah. For more information about the League of Women Voters of San Francisco and ways for you to get involved in our important work on voting rights, please visit our website at LWVSF.org. Or to find out more information about this important study on voting rights barriers in California, please go to LCCR.com. We're continuing our discussion on voting rights barriers in California today. Joining us is Michelle Romero, who's the director of Claiming Our Democracy program for the Greenlining Institute. With 2.6 million voters and 46% of all Californians speaking a language other than English at home, how important is language access to voting?
Well, language access is hugely important. It's a big part of the Voting Rights Act, making sure that we have access to translated voting materials like a voter guide and a ballot, and also access to bilingual poll workers at the polls. But it's so important, really, that as our demographics diversify and we have more limited English proficient speaking people, that we need to look beyond what current law currently provides.
And what qualifications are required for individuals who are translators in polling places and for voting materials?
Do you want to talk about
Yeah, I can speak to that. So there are two sections, and I'll talk about in plain English, two sections of the Federal Voting Rights Act that address language access, Section 203 and 208. And as Michelle mentioned, they require that certain jurisdictions that have over 5% of their population speaking a language other than English provide access to ballot materials, bilingual poll workers, or the option of an assistant of their choice at the polls so that LEP or limited English proficient voters have access to the right to vote. In California, there are a number of counties that are covered under these provisions, but yet there are still problems at the polls. In 2012, 24 Spanish-speaking voters in Los Angeles received Spanish-language robocalls and mailers instructing them to vote on the day after Election Day. So there are still issues with making sure that every voter, regardless of the language they speak, has access to an equal right to vote and knows when the election is taking place with correct ballot materials.
How are large groups being disenfranchised because they're not quite large enough with these formulas for the translation services?
Yeah, well, I'll tell you, I think of the Hmong community, for example, in Fresno. There's a substantial group there that speaks Hmong, but they're not a substantial enough group, according to the Voting Rights Act, to get coverage for the whole county. With the Shelby County decision, I think there's now this talk in the civil rights community of what can we do to restore the strength of the Voting Rights Act. And I think, for me and for Greenlining Institute, we're thinking, okay, well, even if we win every lawsuit, right, even if we restore every provision of the Voting Rights Act, we're still only talking about returning to the status quo. As we look beyond, as we look to the future, and we have a majority-minority nation, we really need to be thinking beyond what current law provides. So let me tell you about one other area, I would say, who's left out, right? The ballot initiative process. California has one. So do about 24 other states. This is how people are making laws and directly passing policies by putting initiatives on the ballot. And it's an English-only process. There is no language assistance for the initiative process. And so how do we make sure that we're applying some of the same standards we have for Election Day to all areas of our democracy?
And I think Michelle is right on in saying that our state initiative process is an essential part of our democracy. It's an essential part of how we have a say in our electoral process, just like the primaries. And if we cut out, 46% of our population, or 2.6 million potential voters, that's disenfranchisement.
Well, Michelle, what's the solution to this?
Well, we changed the law, right? So Greenlining Institute actually introduced a bill at the state level a couple of years back, SB 1233, that would have basically extended the Federal Voting Rights Act protections for language assistance to the initiative process. So if you're circulating a petition in a county that's covered for Spanish or Chinese, let's say, the title and summary of your initiative petition would also need to be translated into Spanish and Chinese.
Thank you very much, Michelle. For more information about the League of Women Voters of San Francisco and ways for you to get involved in our important work on voting rights, please visit our website at LWVSF.org. Or to find out more information about this important study on voting rights barriers in California, please go to LCCR.com. As we continue our discussion on voting rights barriers in California today, we're joined by Ted Jackson, the Community Organizing Director for the California Foundation for Independent Living. We're going to be talking a little bit about barriers to disability accessibility in California and how it impacts the right to vote. Ted, how are you addressing all of these issues?
Well, I think the first thing that you have to realize about accessible voting is that you're talking about a large population that may come to voting in many different avenues and different ways, because the people are as diverse as the disabilities are diverse. So really it's about having a process that's baked in. It's like a cake recipe. And it really isn't a conversation completely about voter accessibility for people with disabilities, but it's like language access that you were talking about with Michelle. It's in all these other different components that you have to have alternate formats, you have to have alternate options for people to be able to request accommodations, because people with disabilities are going to be very different, but they also might only be Spanish speaking or Chinese speaking or English speaking. They come from a wide variety of different neighborhoods, different socioeconomic backgrounds, and so really it's about having that process baked into all of your processes. And I think with accessible voting, it's not even like the 3-layer cake. It is a 7-layer cake, flourless, with a special strawberry filling and everything, because there are so many people. You know, it's also about voting being our primary right and responsibility, and people with disabilities shouldn't be shut out from that right or responsibility. So there's, you know, some very basic things that we need to be thinking about. How are we communicating our voter education materials? How does someone who is blind receive those voter education materials compared to someone who is sighted, compared to someone who is deaf, or someone who has a combination of different disabilities? We also have to make sure that people have the ability to get into the polling place, having that path of travel. If they can't get into the polling place but they can get there, there's things like curbside voting, which is a bit antiquated and relied on a little bit too much in some other places. And then you have the accessible voting machine, which is sort of the universal machine that makes voting accessible, private, and independent for many different types of people with different types of disabilities. And you know, that's been an incredible barrier for us here in California. We've seen those machines aren't maintained as well. They go down. There have been some lawsuits in Alameda County, but especially in the last election, LA County, Orange County, and especially for people who are blind or low vision, who really rely on those machines. And then the other thing that you have to remember is that we're not really talking about a small segment of the population. People with disabilities make up about 20% of the population, which means that somewhere around 4.75 million Californians could be eligible to vote, are eligible voters with disabilities. But also, as we're all living longer with medical science, we are aging our way into disability in greater numbers. So, you know, the diversity of accessible voting isn't just that we need to print something in a particular language or print something a certain way or have something a certain way. It's a variety and a menu of options that folks can choose from. And the last thing that you mentioned is something that I've been working on quite a bit lately, and that's the vote by mail piece. We hear about it a lot. We hear from a lot of folks a lot of pressure to bring in vote by mail as a process here in California, even some counties wanting to go completely vote by mail. The problem for us and for people with disabilities is that is one option on that menu. So you're narrowing it down. And for a lot of folks, if they can't actually physically fill out that card themselves to mail it in, then it no longer becomes a private, independent, and free vote. The other part of it is we know Washington and Oregon have vote by mail, and I've been working on elections for many years now. I have a lot of colleagues up there, and I hear the anecdotal evidence. I hear the stories up there. They still have to have something that's like a polling place, a station, a physical place where people can bring their cards if they're not put into the mail by their ballots, if they're not put into the mail by the certain date. And those places still have to have the electronic machine as guaranteed under federal and state law for people with disabilities. But those places become fewer and far between. So when you switch a county over to vote by mail, all of a sudden you're in a situation where someone who may have been 10 minutes from their polling place could be an hour and a half away. And so for someone who's on a fixed income, maybe on Social Security, who doesn't have a car, who doesn't drive, who relies on paratransit, that could be an incredible barrier to voting.
So Ted, what is the recipe, the most effective recipe for providing training and access in terms of the poll workers, in terms of the proper machines, as well as vote by mail?
Well, in terms of the poll workers and the processes at the county level, I think it's really having your ear to the ground and listening to the disability community. You know, when we talk about any particular community and how to make a process better for them, we know as good people in America that the best way in a democracy is to listen to that group of people. And so, you know, there are things, the organizations across the state called independent living centers. Those are great places for counties to go to and to interact with. And indeed, many of the counties that are doing a good job on voter accessibility for people with disabilities are interacting with their local independent living center, bringing the ILC and the ILC staff in and community members from the disability community to go and talk to and teach cultural competency and, you know, how to ask for or how to provide reasonable accommodations to poll workers. So that's, you know, one piece is really activating the disability community. And the other piece of it is funding. A lot of our machines that are in polling places across California were based on or were purchased with federal funds that came in when Help America Votes Act was passed. And that funding is now going away. Those machines, by the way, also need a little maintenance right now, and they're not working on some election days. Mm-hmm. So we need a continual stream of funding that comes through to the states and to the counties on a regular basis so that we can provide those pieces of accessibility.
Thank you, Ted, and thank you very much for pointing out that we're all temporarily abled. Thank you.
You're welcome.
For more information about the League of Women Voters of San Francisco and ways for you to get involved in our important work on voting rights, please visit our website at LWVSF.org. Or to find out more information about this important study on voting rights barriers in California, please go to LCCR.com. Joanna, let's talk about your findings briefly and what your recommendations are. It's always important to come up with real solutions and people want to know how they can get involved in making those solutions a reality.
Judge Clopton, there are a number of federal and state reforms that we recommend in this report that Californians can get involved in pushing for, based on these ongoing evidence and information regarding barriers and discrimination here in California. So the first federal reform that we recommend is that Congress adopt a known discriminatory practices coverage formula in the new Voting Rights Amendment Act of 2014 to bring California within a new Section 5 federal preclearance protection and oversight structure before discrimination occurs, so that we can prevent it from happening, so that people don't suffer unnecessarily and then have to incur heavy costs and time spent bringing litigation after the harm has already occurred. It's clear that under the current Federal Voting Rights Amendment Act that is proposed in Congress, that it only looks at final judgments regarding voting rights violations. And if it only looks at final judgments, California would not be included. But there are a number of cases, and there are a number of filings that have been brought by the DOJ, given the 9 cases that were brought by the DOJ for language access violations, for example, that would not be counted in that assessment because they weren't final adjudications on the merits in a court of law. They were consent decrees. They were other types of decisions that were made. And again, the California Voting Rights Act, a lot of those cases have settled. A lot of jurisdictions have voluntarily converted.
What other federal reforms can we support?
Well, there's another provision of the Voting Rights Amendment Act that would require notice and disclosure before, as well as federal monitoring after any changes are made to election procedures and systems, so that Californians have access to that information before it's implemented. The other thing that can be done, as we were talking about earlier with Dorsey, to address the racial impacts of felony disenfranchisement laws is the reintroduction and the enactment of the Democracy Restoration Act at the federal level, and the introduction of a constitutional amendment at the state level, and maybe at the federal level, establishing an affirmative right to vote for all residents in the United States.
What exactly is the Democracy Restoration Act?
That was an act that was introduced in 2009 and also in 2011 by Representative John Conyers. It's also introduced this year. It has continued to be reintroduced, and it addressed the right of Californians, the right of any American that has had contact with the criminal justice system but who has served their time to be able to have the right to vote in federal elections.
Let's talk about what we can do right here in our Golden State.
Yes. So the first thing we can do is strengthen the California Voting Rights Act. We already know it can address vote dilution and at-large systems, but what happens after these systems convert to district-based systems? What if they reduce the power of communities of color into smaller and smaller fractions? We need to address that here in California, and while we do have Section 2 of the Federal Voting Rights Act to do that, it's very expensive, very time-consuming to bring that litigation. What we're doing right now, there's a coalition of civil rights groups, Lawyers Committee, MALDEF, NALEO, Asian Americans Advancing Justice, the NWVSF of California and Hawaii, that are working together to strengthen the California Voting Rights Act and enact new legislation that would expand protections for Californians under district-based systems that are experiencing vote dilution.
And what are the other state reforms?
So the other thing that can be done is, as we were talking about earlier with Dorsey, is to designate California probation departments, sheriffs, and other agencies such as county jails as voter registration agencies under the National Voter Registration Act. And as he was talking about under the Help America Vote Act, increase outreach to populations that have had contact with the criminal justice system. This would ensure that over 350,000 Californians, the majority of whom are of color, Latino, and African American, have the right to vote.
And what other kinds of things can we do that don't involve statutory change?
Well, we can update the online registration and voter information system here in California to find ways to identify eligible voters. There are an estimated 5.6 million Californians that are eligible to vote but that aren't registered. We could totally modernize our system that would be in compliance with existing laws under the Help America Vote Act.
And are there other things that the Secretary of State can do in terms of statewide standards?
Yes, adopt clear statewide standards for voter registration and poll worker training, including a cultural competency component so that things like voter suppression, voter intimidation, racial epithets and slurs are not being used by poll workers, and that they truly are providing valuable customer service as a civic duty and are respectful of every single voter and their right to vote.
We've used the term cultural competency several times throughout this program, but what does it really mean?
I think it means what Ted Jackson was referring to when you're saying you're really listening to people. That's the essence of democracy. You really treat a person as you would want to be treated. Cultural competency means you're sensitive to every voter's need.
Thank you so much for all of your hard work in this area and for conducting this study and writing a great report. We appreciate your participation in this program and for working with the League of Women Voters and the Lawyers Committee on Civil Rights, as well as the other organizations that were involved today in this wonderful discussion. For more information about the League of Women Voters of San Francisco and ways for you to get involved in our important work on voting rights, please visit our website at LWVSF.org. Or to find out more information about this important study on voting rights barriers in California, please go to LCCR.com.